Hello and welcome dear students. Today we will be discussing executive election in India and United States of America. The objectives of today's lecture are number 1, to give brief outline of the meaning and importance of elections and political executives. Number 2, to evaluate the working of executive elections in India and its role in Indian political system. Number 3, to understand the role and working of executive elections in US as true federal political system. Dear students, let us first discuss the meaning and importance of executive in India. The executive is that branch of government which carries out or executes the will of the people as formulated in the laws. In the administrative system of India, the executive power of the government is vested in the President of India, who is both the formal head of the state and the symbol of the nation. The Constitution of India, however, bestows authority and dignity to the office of the President without providing adequate powers to rule. Instead, the President performs essentially a ceremonial role. The Prime Minister exercises real executive power. While the President is the head of the state, the Prime Minister is the head of the government. The President carries out the actual functions of the government only with the aid and advice of the Prime Minister. Executive election in India. Articles 52 to 78 in Part 5 of the Constitution deals with the Union Executive. The Union Executive consists of the President, the Vice President, the Prime Minister, the Council of Ministers and the Attorney General of India. The President is the head of the Indian state. He or she is the first citizen of India and acts as a symbol of unity, integrity and solidarity of the nation. The President is elected not directly by the people but by members of Electoral College consisting of the elected members of both the houses of parliament, the elected members of the legislative assemblies of the states and the elected members of the legislative assemblies of the union territories of Delhi and Pondicherry. Thus, the nominated members of both houses of parliament, the nominated members of the state legislative assemblies, the members both elected and nominated of the state legislative councils in case of bicameral legislature and the nominated members of the legislative assemblies of Delhi and Pondicherry do not participate in the election of the President. Where an assembly is dissolved, the members cease to be qualified to vote in presidential election. Even if fresh elections to the dissolved assembly are not held before the presidential election, the Constitution provides that there shall be uniformity in the scale of representation of different states as well as parity between the states as a whole and the union at the election of the President. To achieve this, the number of votes which each elected member of the Legislative Assembly of each state and the Parliament is entitled to cast at such election shall be determined in the following way. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the assembly. Every elected member of either house of parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to members of the legislative assemblies of the states by the total number of the elected members of both the houses of parliament. The president's election is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. This system ensures that the successful candidate is returned by the absolute majority of votes. A candidate, in order to be declared elected to the office of president, must secure a fixed quota of votes. The quota of votes is determined by dividing the total number of valid votes polled by the number of candidates to be elected. Here, only when one candidate is to be elected as president, plus 1 and adding to the quotient. Each member of the electoral college is given only one ballot paper. The voter, while casting his vote, is required to indicate his preferences by marking 1, 2, 3, etc. against the names of candidates. This means that the voter can indicate as many preferences as there are constituencies in the fray. In the first phase, the first preference votes are counted. In case a candidate secures the required quota in this phase, he is declared elected. Otherwise, the process of transfer of votes is set in motion. The ballots of the candidate securing the least number of first preference votes are cancelled and his second preference votes are transferred to the first preference votes of other candidates. This process continues till a candidate secures the required quota. All doubts and disputes in connection with the election of the president are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as president cannot be challenged on the ground that the electoral college was incomplete, that is, existence of any vacancy among the members of electoral college. If the election of a person as president is declared void by the Supreme Court, acts done by him before the date of such declaration of the Supreme Court are not invalidated and continue to remain in force. Some members of the Constituent Assembly criticized the system of indirect election for the president as undemocratic and proposed the idea of direct election. However, the constitution makers choose the indirect election due to the following important reasons. The indirect election of the president is in harmony with the parliamentary system of government envisaged in the constitution. Under this system, the president is only a nominal executive and real powers are vested in the Council of Ministers headed by the Prime Minister. It would have been anomalous to have the president elected directly by the people and not give him any real power. The direct election of the president would have been very costly and time and energy consuming due to the vast size of the electorate. This is unwarranted, keeping in view that he is only a symbolic head. Some members of the Constituent Assembly suggested that the president should be elected by the members of the two houses of parliament alone. The makers of the constitution did not prefer this, as the parliament dominated by one political party would have invariably chosen a candidate from that party, and such a president could not represent the states of the Indian Union. The present system makes the president a representative of the Union and the states equally. Further, it was pointed out in the Constituent Assembly that the expression proportional representation in the case of presidential election is a misnomer. Proportional representation takes place where two or more seats are to be filled. In case of the president, the vacancy is only one. It could better be called as preferential or alternative vote system. Similarly, the expression single transferable vote was also objected on the ground that no voter has a single vote. Every voter has plural votes. Dear students, now we will discuss qualifications, oath and privileges of president. A person to be eligible for election as president should fulfill the following important qualifications. Number one, he or she should be a citizen of India. he or she should have completed 35 years of age, should be qualified for election as a member of the Lok Sabha. President should not hold any office of profit under the union government or any state government or any local authority or any other public authority. A sitting president or vice president of the union, the governor of any state, and a minister of the union or any state is not deemed to hold any office of profit and hence qualified as a presidential candidate. President must be subscribed by at least 50 electors as proposers and 50 electors as seconders. The oath of office to the President is administered by the Chief Justice of India, and in his absence, the senior most judge of the Supreme Court available. Any other person acting as President or discharging the functions of the President also undertakes the similar oath or affirmation. The President is entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official acts. During his term of office, he is immune from any criminal proceedings, even in respect of his personal acts. He or she cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him during his term of office in respect of his personal acts. Let's now talk about term and impeachment of the President. The President holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the Vice President. Further, he can also be removed from the office before completion of his term by the process of impeachment. The President can hold office beyond his term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of terms. However, in America, a person cannot be elected to the office of the President more than twice. The President can be removed from office by a process of impeachment for violation of the Constitution. However, the Constitution does not define the meaning of the phrase violation of the Constitution. The impeachment charges can be initiated by either House of Parliament. These charges should be signed by 1/4 members of the House that framed the charges, and a 14 days notice should be given to the President. After the impeachment, resolution is passed by a majority of 2/3 of the total membership of that House. It is sent to the other House, which should investigate the charges. The candidate has the right to appear and to be represented at such investigation. If the other House also sustains the charges and passes the impeachment resolution by a majority of 2/3 of the total membership, then the President stands removed from his office from the date on which the resolution is so passed. Thus, an impeachment is a quasi-judicial procedure in the Parliament. In this context, 2 things should be noted. The nominated members of either House of Parliament can participate in the impeachment of the President, though they do not participate in his election. The elected members of the legislative assemblies of states and the union territories of Delhi and Pondicherry do not participate in the impeachment of the President, though they participate in his election. No President has so far been impeached. Dear students, let us now discuss election of Indian Prime Minister, who is the real executive. Now we will examine the universal phenomena in the growth of the power and role of the executive in light of the Indian experience of last 30 years. Our starting point is that Articles 74 and 75 of the Indian Constitution establish a preeminent position of the Prime Minister in the central government. He is the head of the Council of Ministers and for actions of the government is responsible to the Lok Sabha. Moreover, in contrast to the ceremonial position of the President, the Prime Minister happens to be the real executive in the parliamentary governance of the country. Indeed, amongst the constitutional offices which have attained immense power and authority in the Indian political system, the office of the Prime Minister figures out prominently. True to the spirit of parliamentary system, the Constitution accords the prime position to the Council of Ministers in the executive framework of the country under the hardship of the Prime Minister, to ward off the probability of the executive system turning into one-man show of the Prime Minister, and emphasizes the collective nature of responsibility of the government. The Constitution does not contain any specific procedure for the selection and appointment of the Prime Minister. Article 75 says only that the Prime Minister shall be appointed by the President. However, this does not imply that the President is free to appoint anyone as the Prime Minister. In accordance with the conventions of the parliamentary system of government, the President has to appoint the leader of the majority party in the Lok Sabha as the Prime Minister. But when no party has a clear majority in the Lok Sabha, then the President may exercise his personal discretion in the selection and appointment of the Prime Minister. In such situation, the President usually appoints the leader of the largest party or coalition in the Lok Sabha as the Prime Minister and asks him to seek a vote of confidence in the House within a month. This discretion was exercised by the President for the first time in 1979 when Neelam Sanjiva Reddy, the then President, appointed Charan Singh, the coalition leader, as the Prime Minister after the fall of the Janata Party government, which was headed by Morarji Desai. There is also one more situation when the President may have to exercise his individual judgment in the selection and appointment of the Prime Minister. That is, when the Prime Minister in office dies suddenly and there is no obvious successor. That is what happened when Indira Gandhi was assassinated in 1984. The then President Zail Singh appointed Rajiv Gandhi as the Prime Minister by ignoring the precedent of appointing a caretaker Prime Minister. Later on, the Congress Parliamentary Party unanimously elected him as its leader. However, if on the death of an incumbent Prime Minister, the ruling party elects a new leader, the President has no choice but to appoint him as Prime Minister. In 1980, the Delhi High Court held that the Constitution does not require that a person must prove his majority in the Lok Sabha before he is appointed as the Prime Minister. The President may first appoint him the Prime Minister, then ask him to prove his majority in the Lok Sabha within a reasonable period. For example, Charan Singh, 1979, VP Singh, 1989, Chandrasekhar, 1990, PV Narasimha Rao, 1991, A.B. Vajpayee, 1996, Devi Gowda, 1996, I.K. Gujral, 1997, and again Atal Bihari Vajpayee in 1998 were appointed as Prime Ministers in this way. In 1997, the Supreme Court held that a person who is not a member of either House of Parliament can be appointed as Prime Minister for 6 months, within which he should become a member of either House of Parliament. Otherwise, he ceases to be the Prime Minister. Constitutionally, the Prime Minister may be a member of any of the 2 Houses of Parliament. For example, 3 Prime Ministers, Indira Gandhi in 1966, Devi Gowda in 1996, and Manmohan Singh in 2004 were members of the Rajya Sabha. In Britain, on the other hand, the Prime Minister should definitely be a member of the lower house, that is House of Commons. Dear students, let us now talk about executive election in America. When the framers of the American Constitution met in Philadelphia in 1787, they found that the issue of the executive created a dilemma. On the one hand, the founding fathers wanted to avoid anything that might prove to be a fetus of monarchy. After all, the American Revolution had just read the new nation of England's George III. On the other hand, the delegates also agreed with Alexander Hamilton that a single executive was needed for decision, activity, secrecy, and dispatch. The founders decided on the presidency, an office that could provide prompt action for a republic in which Congress was nonetheless expected to play the leading role. How should the president be selected? Here the delegates were less clear. One possibility was to allow the national legislature to choose the chief executive. A subcommittee of the Constitutional Convention did canvass this possibility, which would have led to some form of parliamentary government. But the idea that the executive should be beholden to the assembly was not yet established, even in Britain. Had it been so, the convention could well have plumped for this method of appointment. Instead, rather late in the proceedings, the delegates settled on selecting the president through an electoral college appointed by state legislatures. Without realizing the implications, the framers had stumbled across the essential features of presidential government: separate election of executive and legislature. In the presidential system of government, the executive is constitutionally independent of the legislature in respect of the duration of the tenure and is not responsible to it for its political policies. In such a system, the chief of the state is not merely the titular executive, but he is the real executive and actually exercises the powers which the Constitution and the laws confer upon him. The US Constitution provides for a presidential system of government. It provides for the office of the president and makes him both head of the state and the government. He is neither a member of the Congress nor responsible for it. He holds a stable tenure and wields all the executive powers. Article 2 declares all the executive powers shall be vested in the President of the United States of America. The salary and other emoluments of the American president are determined by the Congress and cannot be increased or decreased during the term of office of a particular president. The Constitution provides that the president is to be elected for 4 years. There is no bar for the re-election of the same person for a second time. However, a convention had grown up in the USA that no person shall be re-elected for the third term. This convention was set up by George Washington himself, who was the first president of the America and can rightly be called the father of the nation. It is stated that in 1875, General Grant was half willing to accept a nomination for the third time. However, a resolution was passed that in the opinion of this House, the president established by Washington and other presidents of the United States in retiring for presidential office after their second term has become by universal occurrence a part of their republican system of government, that any departure from this time honored custom would be unwise, unpatriotic and fraught with peril to our free institution. However, this convention was violated in 1940 when Franklin D. Roosevelt stood for the third term. Not only that, he was re-elected for the fourth term in 1944, although he died in 1945. This violation can be attributed to the fact that there was a great danger to the very existence of the democratic countries from the Axis powers. However, the convention regarding no third term was very strong. This convention was given a legal form in 1951 by the 22nd Amendment of the American Constitution. According to the American Constitution, the term of office of the president ends on the 20th day of January of the year following every leap year when the successor comes in office. If the president dies before the expiry of 4 years, the vice president takes over and works as president for the rest of the term. This is what actually happened when President Roosevelt died in April 1945 and was succeeded by Harry Truman, who was at that time the vice president. An act of 1947 provides that in case of death of vice president also, Speaker of the House of Representatives is succeeded. Dear students, let us talk about now method of election. The President of the United States is elected for a term of 4 years by an electoral college. Although constitutionally the method of election is indirect, the growth of political parties and political customs has converted it into a direct method. Any natural born American citizen at least 35 years of age and 14 years a resident within the United States may stand for election. Since no mention is made of the sex of the candidate, women as well as men are eligible. A naturalized citizen cannot contest for presidentship. So far as the nomination of candidate or president is concerned, the Constitution is silent on the method of nomination of the candidates. The founders of the Constitution apparently expected that the Electoral College would perform the tasks of both nomination and election. But the rise of political parties upset the expectation, and now the candidates are chosen by the national nomination conventions of the political parties. Each political party holds a national convention for choosing its presidential nominee. Delegates to the national party conventions are chosen by state party conventions, and in some states by primary elections known as presidential primaries. The national party conventions are held in big cities. A majority of all the delegates is required to choose the presidential nominee. Let us now discuss composition and election of the Electoral College. As we have discussed earlier, constitutionally the president is called by an electoral college formed for the purpose. The Constitution says that the number of electors chosen in each state shall be equal to the number of members of the House of Representatives and of the Senate for that state. In other words, equal to the state's representation in Congress. At present, there are 538 votes in the Electoral College, of which 270 are necessary for election. The election for the Electoral College is held on Tuesday following the first Monday in November. Legally and constitutionally, the voters vote for the presidential electors of their respective states, but actually they vote for the presidential candidate of the party that they support. Presidential electors are nominated by the respective party organizations, and the party may require electors so chosen to promise to cast their electoral votes for the candidate nominated by the party in national convention. In some states, the names of the electors do not even appear on the ballot. The voters therefore regard their ballots for electors as really being cast for the president. Of course, no penalty would attach if an elector should deviate. Not only are the electors known, but also the coming president. These electors are elected on the list system, which means that electors are chosen on party basis. In other words, the party which gets the support of the majority of votes in a state gets all the electors elected. Let us now discuss formal election of president by electors. The formal election of the president takes place long after the polling day through the machinery of the Electoral College. The Electoral College does not formally meet at one place. The electors of the various states assemble at their respective state capitals and vote for the president. The ballots of the state Electoral College groups are sent to the president of the Senate, opened and counted before a joint session of Congress, and the result is formally announced. A candidate, in order to win, must secure a majority of the whole number of electors appointed. If no candidate secures such majority, the House of Representatives chooses the president from among the 3 candidates securing the highest votes in the Electoral College. The House votes otherwise, each state having 1 vote. A quorum for this purpose consists of members from 2/3 of the states, and a majority of all the states is necessary for election. Let us now briefly talk about removal from office of the President of America. The President may be removed from office before his legal term is over on impeachment and conviction for treason, bribery, or high crimes of misdemeanor. The House of Representatives adopts by majority vote of the members present articles of impeachment of charging the person with high crimes and enumerates his particular offences. The Senate acts as the highest court in this regard. The Chief Justice of the Supreme Court presides. 2/3 vote of the members present is necessary for a conviction. If convicted, the offender may be removed from office and disqualified to hold and enjoy any office of trust, honor, or profile under the United States. The party convicted is also liable and subject to indictment, trial, judgment, and punishment according to law. With this, we have ended today's lecture. Hope you have enjoyed it very well. Thank you.